Hello everyone, my name is Mustafa. I'm an associate professor at Ufa University of Science and Technology, Institute of Law, and also legal counsel. Welcome to my channel, Mustafa Contract Law Hub, where I'm planning to tell you about everything you need to know regarding contract law. Whether you are a student, eager to learn, or a professional sharpening your skills, or just someone interested in understanding contracts better, you've come to the right place. So, let's embark on this journey and explore the fascinating world of contract law together. Today, I'm going to talk about this beautiful concept, formalities. And I'm telling you about the details here. In fact, in general, this is the general rule that we don't need any formalities to make a legally binding contract. In fact, all the contracts can be oral, but sometimes maybe based on the jurisdiction and based on the legal system like civil law and common law that I'm planning to tell you about these formalities under these two legal systems, we need some formalities. And when we need them, I listed here three categories. The contracts, the three categories that we need formalities for them. And maybe in other words, we need written version of contracts. These three categories, as you see them, the contracts must be made by deed. And also the contracts must be in writing, or the contracts must be evidenced in writing. First, the contracts must be made by deed. In fact, under common law and civil law, we have this important concept, but by some differences. It's not in both systems, it's not fine in both systems that we say completely similarity there is here. No. By the way, it's the feature of the common law made by deed, because in fact, this making by deed means we have some contracts that we need them to put in special and formal document, in formal framework. And it must be signed in front of witnesses. So you see two elements here must be put in formal document and also be signed in front of witnesses. So you see, under the common law, we have this procedure, but sometimes maybe we see these formalities under the civil law. Maybe you think about the notarizing some documents, or you can call them as notarial deed. But there is some difference here because, by the way, this deed is the feature for common law, and this notarial deeds in fact need to be notarized by the public organization or some public structure under civil law. So here are some examples for common law. You see gratuitous promises that I told you in one of the video that I spoke about the bilateral and unilateral contract, that these gratuitous promises are unilateral contract and only you make promise, and in return you don't have any consideration or promise here. And this must be made by deed under common law. And also the transfers of legal title to land, and it as well must be done or made by deed. And also the certain powers of attorney is another one must be made by deed under common law. And under civil law, I told you about it, that maybe we think about notarizing or notarial deed, but it's not completely the same sense as we have in common law. Here we see this concept by some differences. And here we need these contracts be made by notarizing them, and based on the special jurisdictions, based on the civil law legal system. And so it must be see what kind of code or regulations we have, or in which country you are, because the civil law or common law are the systems that we see them in many of the countries that are the base for their legal system. But in specific situations we have some special codes, some special regulations, so case by case maybe there are some differences and must be analyzed. And also the second one is contracts that must be in writing. So again here, when we speak about the written version, we see some type of contracts must be in written form or written version. There are some differences again between civil law and common law. Here some types you can see as examples. Contracts under common law, contracts involving land, or contracts that cannot be formed within the 1 year, or contracts for sale of goods over a certain value. You see, for example, Uniform Commercial Code of the United States, and also contracts of guarantee. Here you see the contracts for the sale of real estate and certain types of leases, and contracts of donation, formation of certain types of companies, and contracts of employment. So you see this type of contracts, these types must be made in writing, and written version is so important based on the jurisdiction and based on the special code in that country you are working there, or you need to know about that country. And the third category that today I would like to speak about is the contract must be evidenced in writing. What are these types of contracts? In fact, when we speak about this category, we need to know that these contracts are not obliged to be in written version in general, because as I told you, it's a general rule that contracts are not piece of paper. They are agreement, so the agreement can be oral. And here, in general, the contracts can be oral, but maybe some parts, some terms, some obligations or duties under these contracts must be evidenced by writing or in writing. And here I told you about the common law and also the civil law. We see such situation that is so important that some special obligations, some special rules under this or terms under this contract be evidenced by writing or in writing. And even though we don't have this contract in general in written version, and it's not requirement or it's not formality to have this contract, this type, by this subject matter in written version. But we need some special terms here to be in written version or in written form to be evidenced. In future, maybe in some special way that you need them. So, for two purposes here under the civil law, you can see evidentiary value that is so important to be evidenced, and these contracts, and also limitations on oral evidence. And in fact, sometimes you see some contracts that we can't have them or keep them as oral version, and not in general, and we need to have some part of them in written version, maybe mixing them together. Okay, the last slide, look at this figure, that formalities category, what kind of formalities we need in general. I told you we have this general rule that no need to formalities for a contract to be binding, but case by case, based on subject matter and based on the legal systems, civil law, maybe common law, more I'm telling here about civil law and common law, but we have Islamic law as well. Under all of them, maybe we see some special formalities, and we need to focus on them to have legally binding contracts. So I outlined these three categories, as I told you, made by did or be in writing, and also the contracts must be evidenced in writing. Thank you so much for listening to me. As always, I told you about these formalities because I needed to share with you this beautiful concept. Still, I have many beautiful other concepts. Please stay with me and wish you the best. See you soon. Bye.